45 matter relating to or questioning the legality and validity of the rule, amended rule 15(1)(d) and proviso giving exemption to the essential qualification, that is TT pass, to the teachers to get the placement in the seniority list, gradation list, and so also to get the promotion. That is under question, my lord. And my lord was heard also extensively, and I had filed in compliance with my lord's observation a compilation the relevant provisions, my lord.
My lord, two matters are tagged together. One is the validity of statute which they are challenging, and a writ appeal, my lord, where we have succeeded the writ petition, my lord. In the meantime, 68,000 teachers have got promoted, my lord.
Without qualification?
No, with qualification, my lord. You can't say that. But with qualification, my lord. My lord, the rule was amended in the year 2019. My lord, they challenged the validity of the rule in 2023, after 4 years, my lord. Well, within that 4 years, my lord, 68,000 teachers have already got promotion. And my lord, they have not made a single teacher a party, my lord. So I pray, my lord,
I have filed an
intervention application in their writ petition, my lord. So time may be given.
Why are you pointing fingers towards him?
Sorry. Extremely sorry. Extremely sorry.
You file an intervention, who is stopping you? He has challenged
Yes, my lord.
the virus of a rule.
Yes, ma'am.
And your submission that the rule was framed in 2019 and he is challenging in 2023, that cannot be accepted. There is any statutory provision that can be challenged at any point,
Yes, ma'am.
unless that has been upheld earlier by any other decision. All right, so that is permissible. Persons have been given promotion, must have been given promotion because the rule was valid.
Yes, ma'am.
Subsequently, if the rule is held to be invalid, will have consequences. We don't know, prospective, retrospective. So that we will decide.
I have filed an application for intervention. That has not come today.
Today also I am filing an application for intervention. Lordship, let this matter be taken off 1 week after at 2 p.m. 2 p.m. Then it can be had together, my lord, because we have already submitted the writ appeal and the state has preferred a writ appeal, my lord.
My lord, item number WPC 35836 of 23. My lord, it is here in this
The last
bunch of there. Today we have filed the counter. It is a little different from the other, but ultimately the virus will decide all other cases. So, my lord, I have filed, given copies to my friends. And also we have filed counter. The noting says counter not yet received. It is filed today and we have given copies to my friend. Yes.
If I be permitted, your lordship, there are two kinds of dispute. One dispute is with regard to promotion from level 3 to level 2 and level 1. And another dispute is with regard to qualification which is required to promote it to level 4. So this last item is concerned, I am challenging rule 11 subclause 2 and 3. Which is relevant for the promotion to the level 2 and 3. For that purpose, your lordship, they have filed a counter affidavit. I'll prepare my rejoinder.
All right. You are challenging rule 11.
11. They challenge rule 15, your lordship.
Just 11.
2 and 3.
2 and 6.
3.
On what ground?
On the ground that prior to, this is the amendment rule I'm challenging, your lordship. In the original 1990 rules, there was no discrimination. 97 rules, there was no discrimination between a graduate teacher and a lower primary school teacher. For the first time in this amendment,
when anything is amended, that happens for the first time.
My lords.
So that is different. The previous thing was this and later became this. That is also different. You will have to demonstrate that provision violates any provision of the Constitution, any provision of the Act or other law, or any law laid down by Supreme Court. You can also challenge that it is not within the legislative competence of the authority. There is no other ground available.
I do understand.
Right.
About
if you can bring your case within the four corners of this, otherwise unnecessary exercise.
I will, your lordship. I will suggest that, your lordship. But they have filed a counter affidavit today, your lordship, and they have served me the copy right now.
Who are you?
That matter, my lord, that 35836 of 20. That I,
WA.
Yes,
WPC, Your Lordship, WPC.
WPC, my lord.
The last sub item where I've challenged the provision of Rule 11, 2 and 3.
Lingaraj Naik and state, my lord. No, my lord, this is the first matter is we have filed in
Last one, Rule 15.
that is Rule 15, my lord, 17780 of 23. And that we are adopting. That we are adopting in other cases.
In my all the cases.
Only
Is
two,
there
ma-
any
two categories,
provision
Rule 15, Rule 11.
under the rule which has not been challenged?
My lord, what is happening
very-
when there is a
Mr.
amendment? So naturally, some prejudice is being projected before your lordships. What prejudice is given?
The impression which I have been gathering
Yes, my
that
lord.
it is very unsafe for any authority to frame rules.
My lord.
Want to be
It all happened because of that 9 amendment that primary education, the Central Act, my lord. And that thereafter all has to fall in line with the Central Act.
really
Your Lordship,
Today we have
if
filed.
your
May
Lordship,
requested of the parties, list this matter on. When do you want?
2 weeks,
Let it
my
come,
lord,
my
2
lord.
weeks after.
No,
my
no,
lord.
no,
Come
Your
on
Lordship.
Monday, my lord, because they are on the other hand,
sorry,
No, my
my
lord.
lord, taking all these steps to
My lord, 1 week after, my lord, maybe 1 week after.
underqualified persons, my lord.
2 weeks.
Two weeks.
2 weeks to be taken up at 2 p.m. Stop. In the meanwhile, the learned counsel for the parties shall be at liberty to file their pleadings and counter pleadings, if so advised, and exchange them to Stop. Considering the number of adjournments which have already been granted in some of the cases, it is observed that on the next date when the matter is taken up, the court shall not grant any adjournment.
oblige Your Lordship.
May I pray one thing?
The date may the registry ensure that all the pleadings which are filed are duly scanned and placed on record.
May I pray?
Grateful.
In the WPC 10430 of 2024, that is first item. my lord. Even that case, I have already filed an application for intervention. That has not come. IA number 98.
Intervention in what?
Intervention, my lord. In the meantime, my lord, after amendment in 2019, these intervener petitioners, they have already given promotion twice. By relying 19 amendment, when promotion twice from level 5B to level 4.
All right, we will
So
hear you.
that is why I filed an application intervention relying.
Have they challenged your promotion?
My lord, they are challenging Rule 15. If Rule 15
Therefore,
go,
Mr. They are not challenging your promotion.
no, my lord.
They are challenging a statutory rule.
My lord.
So we will give everyone an opportunity if someone wants to argue on the question of law. All right,
I only pray that IA may be
I
listed.
will see.
IA may be listed.
Let-
IA 98.
IA, don't worry. Don't worry for the intervention application in such matters. They are very liberal.